Hello. Welcome to another episode of Read with Me. I'm yours truly, Isabel Badell. I'm one of the owners here and founders of Billionaireette. It is a pleasure to be here with you. And what we do in this particular channel is we read these incredible tools, books, okay? Every single day we're posting videos on different chapters that we're reading, both on personal freedom and financial freedom. If you haven't checked out the personal freedom playlist, it's incredible. Like while I'm reading this incredible book, Invent It, Sell It, Bank It, Vanessa is actually reading The Mastery of Love. And the symbiotic relationship that's building between these two books is really incredible because I really do see the patterns, the patterns between understanding who you are, the relationship that you have with yourself, understanding that you are not really attached. In detachment, you are free. You're more capable of actually pursuing your dream, pursuing what you know can be a hero. And like Lori likes to call it, you either have a hero or a zero type of opportunity. So you have to really understand and educate yourself on how to distinguish those things. So I really love how like Don Miguel is very internal, and how to really internally understand who you are and how you can serve the world. But then boom, you get some tactical exercises, tactical questions, and practicality from the financial freedom side of how I show up every single day to provide you value. So if you haven't checked out the previous video, we talked about funding. There's two parts to chapter 5. Part 1 is all about get yourself some loans, figure out if you want to do it through your friends and family round. You have some SBA opportunities. There's also some VC capital firms that can actually offer you some funding as well. If you are not aware of all those things, make sure to do your research because it's out there, it's for you. And then in the second part, we talked about crowdfunding and how there's 3 different types of crowdfunding out there, the pros and cons when it comes to crowdfunding. Very important to understand that. And then also understanding how when you're putting yourself out there, you have to be conscious of who this is also affecting. It's not just your show. It's not just your product. It's not just your deliverable here. If you have a partner, if you have a spouse, if you have a family, if you're like not just doing this alone, which most of the time when you are running your business, you're not just the only one, involved. Like your family is also involved, whether you have kids or not. They're also involved somewhere, some shape or form. So communication is very, 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 very important in all aspects. So it was really nice how she was able to put that all together and pretty much shine some light into better ways of communication. Okay. So check those 2 videos out. It was really, really valuable. And now we're getting into the truth about patents. And this particular section, I'm very interested about it, this particular chapter, because I've never put a patent out there. Like I've never created a patent. I've always wondered how the process actually goes down. Not that we have like physical products to sell, but who knows, maybe in the near future, we'll come out with a product that we need to know more about patents and all of that. I'm really interested in licensing, when it comes to software, when it comes to licensing businesses and purchasing businesses and having that whole thing go down. But I don't know anything about patents. So I'm really, really excited about this. And if you currently have a patent on something, if you've experienced that whole creating a patent, filing your own patent, or even hiring someone to do that work, make sure to put it in the comments below. I'm sure it'll be a useful resource for someone that's looking for patents and how to create that. So let's get into it, shall we? The truth about patents. This is chapter 6, y'all. Chapter 6. And he goes into one idea can change your future. And this is a quote by an unknown author. This is how she starts this chapter. One idea can change your future. Yes, indeed. All right, let's get into it. One of the first things that I did after designing my first invention was to file for a patent. And now I hold over 120 of them. That should tell you something about how important and how valuable I believe they are. Yet many inventors don't file for patents. There are several legitimate reasons why they make this decision. The primary one is cost. Often, an idea is not patentable. Many inventors have gone on to enjoy successes without patents. So it's certainly not a necessity, yet a patent arms you with so much more leverage should you have to defend an idea in court or in the marketplace. So if this is actually remotely within the range of possibility, I would urge you to try to get one. While the preparations of the application and its prosecution before the patent office won't ever be free, it does not have to be prohibitively expensive either. That said, ultimately, it's an extremely personal choice. Some people can't move forward confidently without a patent. Others believe foregoing a patent is a manageable risk. So while this chapter explores the reasons why a patent is worthwhile and the various ways entrepreneurs can go about getting one, at the end of this chapter, I'll discuss your strategic option should you choose not to file for a patent. Okay. And here are 3 benefits that she mentions that come with having a patent. One is patents equals protection. The second one is going to be conduct your due diligence. And then 3, inventors love patents. So let's get into it. All right. Patents are your best protection against copycats. The United States operates under a first to file patent system. Until just a short while ago, we operated under a first to invent system. So let me explain the difference. Say I invented a product going so far as to create a working model, but I didn't file for a patent. Under the first to invent system, if you came along after me and I filed for a patent for an invention extremely similar to mine, I could start something called an interference proceeding and claim the rights to the invention so long as I could prove that I invented the idea first. Unfortunately, under this system, inventors constantly found themselves in court fighting for the rights to their own inventions, an extremely costly process. The old system was also a problem for the other guy. Many people ceased developing their ideas because they didn't feel they could adequately protect them. There was no way to know whether the minute you filed for a patent, someone wouldn't pop out of the woodworks and claim that he or she had thought of the idea first. And then you were out of luck because the law was on the other side of the person who thought the idea was first, not the person who filed the patent first. So to solve this problem, in 2011, Congress introduced a bill called the America Invents Act, which switched the United States from a first to invent system to, followed by the most other countries in the world, a first to file system. In fact, I was honored that the U.S. Patent and Trademark Office interviewed me at the time so I could explain how much a bill would affect small businesses. I got to attend the signing of the bill and even had President Obama sign the first patent. I believe this new system is fair and more straightforward. Under this new system, however, the burden is on you to file for a patent as soon as possible or risk getting scooped. By avoiding the cost of filing for a patent for your new invention, you could potentially lose all the money you think you're saving and more. And in the future, if someone steals your idea and simply files a patent for it ahead of you, so the person could even come after you for patent infringement, and you could lose all the rights for your invention. We live in a world that thrives on knockoffs. It's incredible how many individuals and companies make their fortunes copying other people's ideas and products. And if you haven't watched chapter, I think it was chapter 4. I don't know. One of those. I shared with you a couple of different examples on how people are using digital products and different ways of knocking off like valuable stuff into making their own business or whatever, into doing that. So let's get into it. I think it was actually chapter 5, now thinking about it. Okay. They're out there, they're looking for easy marks, certain that you won't have the money, the backing, or the backbone to fight them, and they will steal from you. Sometimes if your product has a great promise, a company that wants to sell it will take up the lawsuit for you, but that's the long shot. So with or without a patent, you are in for the fight of your life. But without a patent, you're reduced to fighting with bare fists. A patent arms you with weapons and a shield. If you have a patent and someone infringes upon it, you have options. Your attorney could send your competitor a cease and desist letter. Yes, I was talking about this. That's great. Giving the person the chance to willingly take his product off the market. If that doesn't work, you can alert your competitor retailers to the fact that they are buying from a seller who's willfully infringing on a patent. Retailers really don't like to deal with products that are involved in patent litigation. However, this can go both ways. So get advice from an attorney first. Without patent, there wouldn't be much you could do about someone stealing your idea and selling your product. A patent puts the law on your side and gives you the leverage that you otherwise do not have. 2 important things to remember. 1, the biggest mistake you can make is failing to learn from your mistakes, because that means you'll commit to making those mistakes again. And then 2, the harder the battle, the stronger and smarter you'll be at the end, no matter the outcome. I like that one. Okay. The harder the battle, the stronger and smarter you'll be at the end, no matter the outcome. Indeed. All right. Number 2, conduct due diligence. It would be a tragedy to put your heart and soul, not to mention perhaps your life savings, into an idea to find out once you try to start selling it that there's already something else exactly like that on the market. Now, if you're like every other inventor out there or entrepreneur I've ever met, you probably think this is highly unlikely. You believe that without a doubt in the uniqueness of your product, and you may be right. Or you may be like those 7 women I met when I was consultant for Oprah's Next Big Thing event in Los Angeles, all unknowingly pitching the same diaper bag. You're already traveling a rough road. The fewer surprises you have to face, the better. You have probably already done some research yourself. And the minute that idea popped into your head, you probably sat down at your computer to see if you can find anything else out there that resembled it. I hope you left no online stone unturned. Trawling all the internet vendors, search engines, and social networks like Pinterest, Bing, Google, Facebook, Tumblr, Twitter, Flickr, and Instagram. You also should have looked at every retailer's website that could conceivably carry your product, from the online shopping networks like QVC and HSN to large merchandisers' websites like Amazon, Walmart, Target, and Bed Bath & Beyond. From the big general department stores like Nordstrom, Macy's, and JCPenney's, and Bloomingdale's to specialty retailers like that cater exclusively to your market. This might mean Home Depot if you've invented a tool, or Academy if you invented a new type of fishing rod, but it could also be independent, high-end maternity and baby store in your area that you've invented, say a diaper bag. And of course, while you've been out there walking around, you've probably been keeping your eyes peeled. The thing is, just because you're not finding a product like yours on the web or on retail shelves, that doesn't mean a competitor doesn't exist, or even that no one will challenge you when you try to sell your product. If you start selling an item and someone has a patent on it, you may be guilty for patent infringement. Your competitor would be within his or her rights to try to shut down and with a cease and desist order, or force you to pay a royalty should you continue to sell. It's smart to be well aware of the market so that you don't set yourself up for problems. One good resource could be the patent application process, in which the first step to mine is the USPTO database for any information that could preclude you from getting a patent. If you have no funds and no way to budget for an attorney, you can do this search yourself. But if you can, it is better to hire an expert. Patents are notoriously difficult to read and understand. The legalese can be most unintelligible. Patent attorneys, also known as intellectual property attorneys, go to school for many years to learn how to read and write these particular patents. These lawyers will simply know more than you possibly could about the rules and subtleties within the patent law. Their search will necessarily be more exhaustive than one that you could conduct on your own. Like you, they will search the USPTO website and may search other online search engines. Unlike you, they will have a thorough understanding of the patent classification system and actually know what they're doing. They have years of experience that a beginner entrepreneur just won't have. While you may think it's similar, it could prohibit you from getting a patent that might know otherwise. If you visit the USPTO website, you'll find that at first the process doesn't seem so daunting. The site even provides you with a 7-step guide to help you conduct your search. But although brainstorming keywords and investigating the class and subclasses in which your product should be categorized may not sound too hard, if you're doing it correctly and thoroughly, it will probably be a painful, slow process. And how you will know that you have probably thought of every keyword that could possibly relate to your product. What if it could be categorized under a certain subclass that you didn't even think to check? Your attorney can make sure that no details slip through the cracks, details that could come back to haunt you later. The attorney will do 2 different types of searches. 1, a patentability search to check to see if there are already other patents in existence that could prevent you from getting your patent. And then 2, an infringement search, which checks to make sure that by selling your product, you are not inadvertently infringing on someone else's patent. Though this step is not routinely done, I think it's smart. It's a smart thing to do, and I recommend it. The comprehensive search alone can be worth the price of your attorney. Based on the results of these searches, your lawyer will be able to tell you the likelihood that you will get your patent. If your attorney believes that you have a good shot, you can decide whether it's worthwhile to continue. And if your attorney is doubtful you'll get your patent, you can stop trying to get one. Either way, you have done due diligence and possess important information about the competitive landscape, which will allow you to make an educated decision about the best way to proceed. That's very interesting. The 2 different ways that actually like the lawyer or the attorney can actually help you with. Those are 2 ways of looking at it. Investors love patents. A patent makes you protect A patent makes your product more appealing to investors because it reassures them of your ability to corner the market, which gives them a better chance of profiting from their investment. It also gives them something to sell. For any reason their investment in you doesn't pan out, even if they love your idea, they don't really need you. They need your patent. You will have a much easier time getting funding and funding partners if you can claim that you hold a patent on your invention. And it makes me think like, okay, as like a digital company, what kind of patents can you actually put together based on your industry, based on your expertise? What kind of patents can you put together? What kind of patents can you put together? And just asking yourself that question, because now more than ever, everything is digital, and having the ability to leverage a product or a service or something in the digital space, it can be extremely lucrative if you have a patent or a trademark or even a copyright attached to it. Okay. The cost for filing a patent. Filing for a patent may cost you less than you think. Your initial layout for an intellectual property lawyer could be anywhere from $2,500 to $15,000, depending on the type of patent you are pursuing, the seniority of your attorney, what firm you use, and the city that you live in. So, for example, if you're filing a patent for a simple product, it might be less expensive than if you were filing for something in biotech, which is much more involved and costly. There are steps that you can take to minimize the cost filing. And she actually gives you 3 different ways. A relatively inexpensive junior attorney will still know a lot more than you do and would be well worth the investment. There are ways that you can minimize your fees too. A basic filing fee for a utility patent costs $1,600, but if you qualify as a small entity, which means you employ fewer than 500 employees, the cost is reduced by half. And as a result of the American Invents Act, as of spring 2013, you can also apply as a micro entity if you qualify, in which case your fee would drop by 75% to $400. Filing for a provisional patent could actually cost an inventor as little as $65. Filing for a patent does not have to be an exorbitant investment, especially if you can figure out a way to mitigate the cost of a patent attorney. You can file your patent yourself online. It's called filing pro se. Pro space SE, pro se. And it costs about $1,000. It's not easy. A patent is rarely granted after the initial filing and almost requires some back and forth between the applicant and the patent examiners who believe they have found a reason to reject a claim, but it can be done. Wow. I strongly believe, and she mentions this in capital letters, y'all. While I strongly believe that it is worthwhile investing into someone that can help you. So worthwhile the investment to spend the money on someone who can help you put your best foot forward, who knows the ins and outs in patent law and can increase the likelihood of you getting your patent. The last option sometimes works. I knew an inventor with a clever idea who filed her patent herself and she got it. We wound up working together and her product sold very well. For certain products, especially simple ones, it may be worth a shot if the alternative is not to file at all. And then she goes into the 5 steps into actually filing your patent. Okay. So the 5 steps to obtaining a patent. 1, hire a patent attorney. As I said, I advise inventors to file for their own patents only as the last option. If you wouldn't feel qualified to go into court and file your own case, you shouldn't try to file your own patent if you can help it. A patent application has to be written with extreme caution. Every word matters. Attorneys understand the system, they know the pitfalls, and they are worth the investment. In addition, filing your own patent actually lowers your chance of getting the patent because You just don't know what you don't know. Some researchers estimate that the number of inventors who fail to obtain patents after filing pro se may be as high as 75%. Not every lawyer is qualified to handle patent law, which is exceedingly complex and nuanced. Before hiring your intellectual property attorney, ask around, do your research, get recommendations. There are two things you want to find out at this stage. Number one, does this attorney specialize in an area relevant to your product? All registered patent practitioners have a technical degree, such as chemical, mechanical, or electrical. You want an attorney who knows your field as well, if not better than you do. And then number two, is the attorney a patent prosecutor or a litigator? Unlike the prosecutors that you've seen on television, patent prosecutors don't actually try anyone in court. Rather, they are the attorneys who write the patents and submit them to the USPTO in Washington, D.C. A patent litigator, on the other hand, fights patent infringement cases. Before hiring a patent attorney, make appointments with your candidates and meet them in their offices. This is extremely important, and not just because you're about to spend some money. As in every profession, there are good attorneys, great attorneys, and attorneys you need to avoid like the plague. It's always going to be a mixed bag. You've got to meet your potential candidates in person and question them around your product. Do they understand your field and the technology behind your idea? Do they seem confident that they would know how to prosecute a patent for a product like yours? The person you hire to file your patent will be taking your future into his or her hands. It's crucial that you like and trust your attorney, and that you feel confident he or she will successfully get you a patent. It is possible that you could go through all the trouble and expense of filing a patent and still be denied. Only an experienced dogged patent attorney will, it is hoped, be able to help you around that roadblock. You also want to hire someone who will be honest with you about the likelihood of getting your patent so that you don't waste your money. But if all goes well and you bring more products to the market in the future, this could be the beginning of a long relationship. You want to feel good about this partnership. After your attorney conducts a patentability search and believes that your idea is eligible for a patent, you will begin the filing process. Remember, a search is not necessary, but I recommend it because it helps your attorney draft a better patent. Choose your patent. Individual investors generally pursue three types of patents. The most common are utility and design, though there is a third plant patent for the agriculture arena. A utility patent protects the function of a product or idea, the actual mechanics of how it works. A design patent, on the other hand, protects the aesthetics of the product. The only thing a patent examiner will look at upon receiving a request for a design patent is its similarity to existing designs. A design patent is easy to get, but it's also harder to defend because sometimes it is easy for a competitor to work around by making a few small changes. Some people first file a provisional patent application. Inventors often do this when they haven't quite cemented the details of their invention. It's a stopgap, an inexpensive way to get your filing date on the books so you can protect your idea per the rules of the first to file system, while giving you a chance to make sure the product is good and that there is a market for it before bothering with the additional expense of a utility patent. Your provisional patent application will outline all the important details about your invention. If you filed a provisional patent application, you have 1 year in which to file your utility patent. Otherwise, the provisional expires and you lose the benefit of an earlier date. And then number 3, write your claims. Once you've decided which type of patent you're going to file, Your patent attorney will file a number of claims. The first is your independent claim, which includes all the main minimum elements you want to cover. You want your main claim to be as broad in scope as possible. You will then have dependent claims in addition to the main claim that further narrow the scope of protection. In my first patent on my earring organizer, my broad independent claim claimed for a base having a plurality of grooves and a plurality of separate strands, each being received in a groove. One of the dependent claims added that the fact each stand had a cross piece extending between respective supports of the stands. Now you understand from reading that language why people shouldn't attempt this with an attorney. Notice that I wasn't specific about the height, length, or material used. You always want to draft your claims as broadly as possible, so not to limit the scope for things like size or materials, which would narrow your protection. It is important to have claims of varying scope to well protect your invention from challenges of invalidity, which a defendant in patent infringement lawsuit will often claim. Once your patent is filed with the USPTO, it gets stamped and dated, and then you wait because at any given time, there's usually a backlog of about 600,000 patent applications ahead of you at the USPTO waiting to be processed. At this stage, your product is patent pending. Some people choose to wait before moving forward, but most people continue to pitch their idea to buyers and market and sell it while they wait for their patent to be approved. I understand the instinct to be cautious, but it's better to get there and sell because for all you know, you may never get your patent. It would be a shame to lose time that you could have been selling, waiting for something that may never come. Sell now with the anticipation that all will go well and you'll have your patent. If you don't, you can decide what to do then. You don't have to stop selling if you don't have one. A patent is like insurance. You may need it and you hope you won't. Nevertheless, it's good to have one if you can get one. Being able to say that your product is patent pending is like sending a warning signal to knockoff artists. You're still vulnerable to predators like a lamb in the field, but with a patent, or at least with the application of a patent on file, you're a lamb in a comfortable, safe enclosure. Without anything on record stating that you intend to defend yourself, you're a lamb who the wolves are watching. If an unscrupulous competitor or company spots your product and thinks that they can make money with it, they'll look up your patent application and see if they can design around it. That's why it's important for you to file good claims that are difficult to write around. Of course, if knockoff artists see that you haven't filed a patent at all, your invention is easy pickings, a tasty tidbit for a money-hungry wolf. After you file, an examiner will start reviewing the USTPO database for prior art. Prior art of any other patent, domestic or foreign, articles, books, catalogs, and even events that might tangentially have to do with your product. Keep in mind that you also have to tell the USTPO about prior art you are aware of. The examiner digs for anything that could throw into question the originality of your idea and therefore make it undeserving of a patent. Most of the time, after this exhaustive search, the examiner will not send you a definitive yes or no. Rather, you get something called an office action, a document that outlines which of your claims have been approved and elaborate on why others have been rejected. This is another reason why there is no point in waiting around, biting your nails, praying for your patent to go through. It is rare for any patent application to sail through to an approval intact and its first try. Number 4, review your office action. There are many reasons why you might not get a patent. One of the reasons is that something too similar to your product already exists. There might not be much that you can do about that, but any other reason may be that your idea was judged to be too obvious. For example, though you may fervently believe that inserting an LED light into the brim of a baseball cap is wholly original, the examiner might determine that, in fact, adding a light to a cap is obvious. Anyone could do it. Therefore, the invention does not warrant a patent. If this scenario were to happen, and it happens frequently, you would be glad you hired a patent prosecutor. On your own, it would be extremely hard to convince the examiner to reconsider. An experienced patent attorney, however, will be familiar with a host of previous legal decisions in which to base an argument that, in fact, your product is not obvious. Number 5, decide whether to pursue your claims or abandon the application. As you review your office action, you and your attorney will discuss the results and decide whether to proceed in pursuing the patent. What's important to consider at this stage is not necessarily how many claims you think you can fight for, but which claims are worth fighting for. If the examiner reply indicates that there is little prior art or your attorney is confident he or she can come up with a strong enough argument to turn around the rejection of an important claim, it's probably worth following through to get those claims, especially since you've already invested the money. If the only claims your attorney thinks he or she can get approved is a claim that doesn't offer much protection because it's too narrow to be helpful, it's probably not worth the time or the money to fight for it. And if your lawyer tells you that the odds are you're never going to get your patent, why fight a losing battle? Stop, cut your losses, and continue to sell. If you decide to pursue the patent, there can be a lot of back and forth, and your attorney pushes back against disputed claims. There are usually several rounds during the examiner denying some of the claims and grants others. And then your attorney responds with arguments as to why the claim should be granted. It's a process that can take a long time depending on the arguments surrounding the patent. A design patent can take as little as a year to obtain, but a utility patent can take a lot longer. I had to wait almost 7 years to get one of mine. Recently, however, the USTPO passed initiatives to help cut the time it takes to get a patent. You may have to pay a significant amount more to take advantage of the new programs, but it allows you to put your application on the accelerated track. Trademark protection too. In addition to protecting your particular invention via patents, entrepreneurs should likewise consider securing trademark protections for their brands, logos, designs, and slogans. A trademark is a word or words or logos, slogans, or any combination thereof used as a source identifier for a product or service. In some circumstances, even the unique shape of a product can be protected as a trademark. It is important to understand that trademarks are not owned across all products and services categories that are limited only to the product category or categories for which a particular trademark is used. As such, the trademark CRC might be owned by one company in connection with lawnmowers, whereas the trademark CRC might also be owned by another company in connection with breakfast cereals. Since most lawnmowers companies are now also in business with breakfast cereals, consumers are unlikely to think that the parties' respective CRC products originate from the same source or company. Generally speaking, trademarks can be earned in one of two ways in the United States. The first, common law unregistered trademarks rights, can be achieved merely by using a particular trademark in the marketplace in connection with a particular product or service. Common law trademarks are territorial and give one right to the trademark in connection with a particular product or service only in the geographic region in which that person or business is using the mark. Conceivably, it is thus possible to have CRC branded lawnmowers for sale only in California. That will not cause any consumer confusion with another CRC branded lawnmower for sale by a different company only in New York, since the geographic reach of these businesses does not overlap. Second, the trademark rights can be achieved by filing for federal trademark protection with the United States Patent and Trademark Office. Federal trademark rights are much broader than common law trademarks in that they are presumed to grant in the owner nationwide trademarks rights and additional rights and remedies not available to common law trademarks rights holders. Obviously, it's critically important to protect one's brands as trademarks, since some consumers rely on their brand for clues as to quality and reliability when making their purchasing decisions. Trademarks give the entrepreneur monopoly power to be the sole user of a particular brand in connection with a particular product and service, and the product to prevent a third-party copycat from using confusingly similar name on a related product in the marketplace. Much like preparing to patent your invention, it is critical to conduct your due diligence prior to using your trademark or logo in order to ensure it is valuable for use and protection. The first step is to often visit the United States Patent and Trademark Office website to make certain no third party owns a particular trademark in connection with a specific product or service. While you can certainly visit the USTPO website for initial due diligence, you're also likely best served by retaining a trademark attorney to conduct a full availability search so that you can appropriately assess availability of your new trademark and the likely risk associated, if any, with launching your new product or service under your new trademark. Once it is determined that your new trademark is a good candidate for your use and registration, your attorney will be able to prepare for you an application for registration of the trademark. In most cases, is approximately $1,000 for a single class application. Great. And then the last part here, how to bring your product to market without a patent. Okay. Should you decide to abandon your patent application, or that you can't justify or shoulder the expense of applying for a patent in the first place, what then? Is it game over? No, because most of the products don't have patents or aren't patentable anyways. Just get it out there and try to blitz the market. You will need to get your product into the market first, and then spread it to as many retailers as you can. The bigger, the better, so that by the time the competitor gets to it, to get its version out there, your product and brand have captured consumers' hearts and minds. Actually, you should plan to take this course of action even if you decide to file for a patent. It's always been my strategy to do both. Admittedly, for a new entrepreneur, it's an uphill battle. It's not easy to get buyers to pay attention to you when you're unproven and unfamiliar. Like everyone else, they prefer to do business with known entities, and the major players have incentive to take a chance on you, have no incentive to take a chance on you. There are steps you can take to improve your chances, however. Here are 3. Hire a distributor or a firm with extensive retail connections to represent you. See Chapter 7 for more details on how these companies work. Get backing from a prominent investor to burnish your image. Appear on Shark Tank and make a deal with one of the Shark's investors to prove to buyers that the market wants what you've got, and the wave of free publicity won't hurt either. In the case of Shark Tank, the Shark's expertise and clout can be extremely valuable, even if you have to give away a percentage of your business. Investors can help you get over the barriers of entry and get your product into many retailers so you can spread a wider net. And as everyone knows, once your foot is in the door, it's much harder for people to slam it into your face. But imagine if you could do all of that with the additional protection of a patent. This wonderful, unique product you've invented probably means everything to you. A patent offers more than just protection. It gives you choices and the ability to determine your own fate. It's empowering, and that's priceless. Just ask the drop stop boys, as they told me, when the knockoffs and counterfeits started surfacing. It was like a blow to the gut. It hurt a lot. We felt helpless. It took them 5 years to finally get their patent so they could fight back. Today, almost all the copycats are out of business. And since negotiated with the deal with Shark Tank, the drop stop couldn't be doing better. They sold more products in 3 months after making our deal in Shark Tank than they ever did in 3 years on their own. A surprising number of individuals receive patents and then never bring their product to market. Maybe something in their life changed and they lost interest in their invention. Maybe they only got the patent in case they decided they wanted to license the product one day. Maybe they just got tired of flying blind. It's only very recently that people have had easy access to information and programs that could educate them and show them examples of how other people did it. Or maybe they finally realize how hard it is to be an entrepreneur. It takes a rare person to follow through with something like bringing an invention to market. And the process for patent is just one of the several difficult challenges you will face. But if you plan on being patient and persistent, and your market research is encouraging, and you're being creative and dogged in your pursuit of funds, and you're just overall prepared for the long haul, you're already way ahead of many of the peers and competitors. So here's a patent to-do list. 1, conduct due diligence to make sure there's no other product in the market like yours to see if you could be infringing on someone else's patent. In order of importance, you should start with these outlined sites. 1, go to the USPTO, the database, Amazon, Google, online retailers, Facebook, Pinterest, general department stores, specialty retailers, Twitter, big box stores, Bing, Instagram, Flickr. Hire a patent attorney if at all possible. If a patent attorney is out of the question, file pro se. If foregoing a patent altogether, start blitzing the market. And then 5, get a trademark if applicable. Awesome. Well, that was one heck of a chapter. Lord, learned a lot. It was a lot. And if you haven't filed for a patent, make sure to look up the information required. Maybe, and I'm curious, like it just makes me realize like that's a lot of work for just a patent. And then most of the time it takes a really long time to get it. I wonder if you can file a patent and then in 5 years' time, maybe that idea doesn't even work anymore. Or maybe you file a patent for future stuff that you predict it can become. And then in the future, it turns out to be real. And then now you have a patent for it. Interesting. Anyways, it can go into so many different scenarios. So I hope you enjoyed this chapter. It was a long one, but it was a good one. A lot of information. I feel like I read an encyclopedia, but honestly, it was well worth it because it'll stay in my subconscious. And then whenever, I need to file a patent, I know I need to go to the USTPO to get that thing done. And I need to file a pro se, and I also should be hiring a patent attorney because the language in there is ridiculous. So go ahead, check it out, and make sure to consider hitting subscribe and liking this video. It will definitely help with the channel. So have a great, amazing day forward. Talk to you soon. Bye.